Good afternoon, everyone. I hope you've all had a nice lunch. So now we are going to start the second part of the agenda for the conference, which is an issue that has exercised the public for many, many months now, which is the issue of atrocities against scheduled tribes. This work that we are going to present today is research that we have been doing since the Supreme Court judgment in the Kashinath Mahajan case came out. Which created the controversy around this issue. And essentially, we were trying to unpack the claims and counterclaims that were being made by various groups about the issues and controversy in that case. But also, this is work that is sort of building on the work that we did for the report, which was the basis of discussions in the previous session, because our experiences with people on the ground tell us that how criminal law is used to displace people. So we did want to do our research on criminal law provisions and how they may be interacting with the civil law provisions relating to land and so on. But in that context, we also wanted to look at the Atrocities Act. But this is research in progress. This is the first time we are presenting this research. We very much welcome your feedback on this work. So just to give you an overview of the presentation, I'm going to speak briefly about the constitutional framework demarcating scheduled castes and scheduled tribes, a bit of which was covered in the last session, and then the constitutional legal framework for protecting rights of scheduled castes and scheduled tribes, to which Shomona also adverted to in the last session. Then specifically about the issues and controversy in Subhash Kashinath Mahajan versus State of Maharashtra, the Supreme Court judgment that was rendered this year. And then an attempt to sort of understand the data on atrocities against scheduled tribes, and which is there in the National Crimes Records Bureau, as well as understanding trends in criminal convictions of scheduled tribes, which is from prison statistics data that we have collected. Without further ado, we know that, as I mentioned in the previous session, Article 366 of the Constitution defines both scheduled castes and scheduled tribes. And the definition of scheduled castes is very interesting, because scheduled caste is defined to mean such castes, races, or tribes, or parts of or groups within such castes, races, or tribes as are deemed to be scheduled castes for the purposes of this Constitution. So within the definition itself, there is a considerable degree of overlap between castes and tribes, which is also why often we see that there are many provisions that relate both to the scheduled castes and scheduled tribes. Article 366, Clause 25 of the Constitution defines scheduled tribes to mean tribes or tribal communities or parts of or groups within such tribes or tribal communities as are deemed to be scheduled tribes under Article 342 of the Constitution. And essentially, Article 341 and 342 give the President the power to declare who is a scheduled caste and who is a scheduled tribe in a particular state or union territory. And like I said, there is considerable degree of under-inclusion, over-inclusion, and overlap between these categories in different states. Now, thanks, Shomona, for your presentation, because you spoke about all of these articles in your presentation, which sort of encapsulate the equality framework in the Constitution. So the most important, the first article is Article 14, which says that the state shall not deny to any person equality before the law and equal protection of the laws. Now, this is a general guarantee of equality that applies to everyone, but not everyone is the same. Only like can be treated alike, unlike cannot be treated alike. So that is why the Constitution's definition of equality has a substantive element which goes beyond the formal equality in Article 14. Article 15 safeguards the rights of all citizens against discrimination on grounds of religion, race, caste, sex, or place of birth. You may note that the word tribe is not there in Article 15, and there is a reason in the constitutional imagination, scheduled castes and scheduled tribes, even though they are often put together and there is a considerable degree of overlap sometimes between the two categories, there was a different understanding of the injustices against these two communities. Scheduled tribes, scheduled castes were understood to be people who were within mainstream society but had suffered systematic discrimination. whereas scheduled tribes were those who were seen as having a distinctive way of life outside the mainstream of society, whose historic injustices stemmed for the same reasons that we have been deliberating today, which was essentially that their lands and resources had been colonized and exploited by the British state. So there is a very different, there is narratives of injustice. One is a narrative of discrimination, and the other is a narrative of sort of colonial exploitation outside of society. And then we look at Article 21, which was really the issue in the case of Subhash Kashinath Mahajan, which is that no person shall be deprived of life or liberty without procedure established by law. And this provision is very important, like Article 14, Article 21 are some of the provisions which apply to all people in the territory of India, not just citizens, as opposed to Article 19, which is about personal liberties, which applies only to citizens. So these are the fundamental guarantees in the Constitution. But the Constitution also has a chapter on directive principles of state policy, Article 46 of which imposes a very clear obligation on the state to promote with special care the education and economic interests of the weaker sections of the people, and in particular of the scheduled castes and the scheduled tribes, and to protect them from social injustice and all forms of exploitation. So again, the way we structured this conference, in the first session we were focusing on the 5th and 6th states with 5th and 6th scheduled areas, but as you will recall, I mentioned at the beginning that there are 750 tribes in 26 states and 6 union territories of India, but there are only 14 states that have scheduled area guarantees, and Professor Fernandez spoke about it. Many of you in the audience have been talking about states where there are significant tribal populations that do not have these constitutional protections, but the constitutional protections stipulated in the fundamental rights chapter for scheduled tribes apply also to those to those people in those states which do not have scheduled areas, and can be used, as Shimona also suggested, to weave a narrative of substantive equality that can help further the claims of these groups of people. Now, again, I mentioned in the previous panel as well that there are special protective provisions for scheduled castes and scheduled tribes. I mentioned 4 things in the panel in the morning, 3 of which apply to both groups. The first is special political representation. Within the federal constitutional framework, there are reserved seats for both scheduled castes and scheduled tribes under Article 330 of the Constitution, read with the Representation of Peoples Act. Then Articles 15.4 and 16.4 of the Constitution stipulate affirmative action guarantees that reserve 7% seats in government-funded educational institutions and government jobs for ST. Sorry, there's an error there. It's actually 15% for SCs and 7% for STs. And then Article 17 of the Constitution abolishes the practice of untouchability and declares that the enforcement of any disability arising out of untouchability is a punishable legal offense. Now, this provision was introduced in the Constitution to reverse systematic injustice due to discrimination stemming from this practice against the scheduled castes. Now, in order to effectuate these constitutional directives, Parliament enacted the Untouchability Offences Act of 1955 shortly after the Constitution was adopted in 1950, which was in the same year amended and renamed as the Protection of Civil Rights Act. This act remained in force and still in force it is still in force, but it was in force for about 30 years. But what we saw was the act was not considered strong enough to check instances of atrocities. In fact, there were widely reported instances of atrocities, including massacres against both scheduled castes and scheduled tribes in various places. Finally, under pressure from various members of parliament and so on, government began monitoring of atrocities against scheduled castes since 1974 and against scheduled tribes since 1981. And eventually, this culminated in the enactment of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act of 1989, and rules were framed under this act in 1995. When we look at the Lok Sabha debates on the issues that people were raising when this act was actually passed in 1989, they highlight massacres and mass violence against scheduled castes and scheduled tribes due to 4 main causes. But again, we don't have, the debates mention these things again and again. There are various committee reports, including by the National Human Rights Commission, which have also highlighted these causes. But again, we don't know which causes are more in which states. Again, data is absent. And so that was our starting point of inquiry of this research as well. But largely land disputes, There are members of parliament in the 1989 Lok Sabha debates who are saying land disputes contribute to almost 60% of atrocities against Dalits and Adivasi communities. But also economic exploitation, of which money lending was a big part, political representation, violence with respect to electoral contests and so on, and social exploitation. And within that, even though the members in 89 are not really speaking so much about women in particular, we find that increasingly, and our data also shows that that's a big issue. So what are the important features of the Prevention of Atrocities Act? The first thing to note is that it covers only those offences against scheduled caste and scheduled tribes individuals and groups by people who are not from scheduled caste and scheduled tribes community. So for instance, if a scheduled caste person commits a crime against a scheduled caste person, then that would not come within the purview of the act. But crimes by non-SC, ST people would come. Then only a person from the scheduled caste and scheduled tribe community can be a victim of an atrocity under the Act. This is different from the Prevention of Civil Rights Act of 1955 because that did not actually define any particular group as such. This Act enlarged the scope of criminal liability by including several acts or omissions within the definition of atrocities, which were not covered either by the IPC, the Indian Penal Code, or the Protection of Civil Rights Act, including, and this is particularly relevant in the question of landlessness, wrongful occupation or cultivation of land owned or possessed by scheduled castes and scheduled tribes, dispossession of scheduled tribes of land, or interfering in the enjoyment of their land, forest, or water rights are all atrocities which are punishable as legal offences under this Act. It also enhanced punishment for commission of offences against scheduled castes and scheduled tribes, and it weakened certain procedural safeguards available to persons accused of committing atrocities. The first thing it did was it prohibited grant of anticipatory bail to the accused, and it also excluded application of Probation of Offenders Act of 1958. And this issue was, the exclusion of anticipatory bail was squarely an issue before the court in Subhash Kashinath Mahajan. It also enhanced the minimum punishment for public servants, and even neglect of duties by a public servant was made punishable under this law. Even neglect of duties is made punishable. And finally, it mandated establishment of special courts and special public prosecutors for ensuring a speedy trial, and also protected rights of victims and provided for their rehabilitation. It also protected witnesses of crimes. I mean, the Act was basically responding to a social reality where these groups were so oppressed within society that it was very difficult even for them to bring a claim and to sustain it through the legal process. So ये जो वास्तविकता थी उसको respond करने के लिए ये law बना. Now let us look at the Subhash Kashinath case, which was decided by the Supreme Court. I will not go into the facts of the case because the Supreme Court is essentially a court of law, and it was asked to pronounce on the questions of law that were before it. You know, appellants in this case challenged the constitutional validity of Section 18 of the Prevention of Atrocities Act, saying that it violated the guarantee of equality and right to life and personal liberty under Article 14 and 21 of the Constitution. Section 18, as I mentioned, precluded the application of the Criminal Procedure Code, which allows for grant of anticipatory bail as a right if certain conditions are met. So it empowers the High Court and Sessions Court to grant anticipatory bail to a person who is accused of an offence, but under the Prevention of Atrocities Act, this has been done away with. Now, the Supreme Court had, this was not the first time the Supreme Court had to address this question. The Supreme Court, through a division bench ruling, Subhash Kashinath Mahajan is also a two-judge bench or a division bench as lawyers call it, previously upheld the constitutional validity of Section 18 in state of MP versus Ramakrishna Balotia. So there was a 1995 Supreme Court judgment where the court had said that yes, Section 18 precludes anticipatory bail, but in the special circumstances of the Prevention of Atrocities Act, that's fine. But in court in Kashinath, it referred to this precedent, but it said that Balotia was not binding because it ignored a precedent by a 6-judge bench in Gurbaksh Singh Sibia versus State of Punjab, a 1980 case. So basically, Kashinath and Balotia were equal judge bench strengths, and they should ideally, if Kashinath wanted to take a position, I mean the Supreme Court in Kashinath wanted to take this position, they should have referred the matter to a larger bench. But this is an increasingly common practice that, it was also the issue in the land acquisition case that was decided by the Supreme Court in March. The matter should have been referred to a higher bench because there was a bench of equal strength that they were disagreeing with, which had settled the law on the application of the new Land Acquisition Act 4 years ago. But instead of doing that, they said they distinguished it on some grounds and did not refer the matter to the Constitutional Bench. Eventually, it has been referred to a Constitutional Bench, which is hearing the issue. That is what this court, if it really wanted to do something in this case, that's what it should have done. But it didn't do that. Instead, it said that Balotia was wrong because it didn't look at a previous law. And it said that, no, we are not really striking down Section 18. But if it is not a genuine case, then, Section 18 should be available because it is a statutory right. And then it went on to cite rampant misuse of the law without any statistical evidence as to what they mean when they say there is rampant misuse. Except to say that because a number of atrocities registered and number of acquittals in atrocities cases is very high, so therefore, and that also they relied upon, material presented only by the amicus and on certain, from certain states. They basically said that because acquittal rates are high, so, most cases must be misused, and therefore, we need to allow the accused to have the right to anticipatory bail. So basically the court held, no, there is no absolute bar on grant of anticipatory bail where no prima facie case is made out. No, prima facie means on the face of it. It's a Latin word term which means on the face of it. So on the face of it, if there is no case that is made out, can't be an absolute bar on the court to grant anticipatory bail, where on judicial scrutiny, the complaint is found to be prima facie malified, which means that it is with a wrongful intent. The second thing they said, can be no arrest of a public servant without approval of the appointing authority and the recording of reasons for the same, and no arrest of a non-public servant without approval of the Special Superintendent of Police and the recording of reasons. In both these cases, the magistrate must also scrutinize these reasons before allowing detention. So basically, it included several bars which were not there in the law. First, it said that you can get anticipatory bail, even though there was a clear prohibition, when no prima facie case is made out. With respect to this other provision regarding arrest of public servant, it said it has to be with the approval of the appointing authority, which is very hard to get, and the recording of reasons. And for a non-public servant, without approval of the police and the senior superintendent of police and recording of reasons. Now, it must be emphasized here that there are very serious and important values at stake in the Kashinath case, and they are really about personal liberties, both of the accused and of the victim. On the one hand, we have a commitment because we are a country which believes in the rule of law. We believe in a fair trial. We believe in the presumption of innocence. Everyone is to be presumed innocent unless he or she is proven guilty. And that is a safeguard that is available to everyone under Article 21 of the Constitution, which is why even, when you have, for instance, the trial of Ajmal Kasab, there was eyewitnesses and so on that he had committed these terrorist acts, but he was still, he had to go through a fair trial where that evidence was adduced, and it took years to convict someone like him. So the personal liberty of the accused is very important because it comes from the fact that, the state has all this power against all of us. And so we all must have the right to defend ourselves. But on the other hand is the value of the rights and liberties of the victims, especially from the most disadvantaged groups in our country, the scheduled castes and scheduled tribes, who are the most vulnerable groups of our society. And I think that's where what Shomana was mentioning about the substantive equality dimension of the Constitution comes all, because the first value applies to all of us, and as it should. But the second value actually recognizes that all are not equal, and that perhaps the personal liberties of the accused may sometimes have to be weighed against the rights and liberties of victims from scheduled castes and scheduled tribes community. Now, there have been many criticisms of Kashinath, which the ones that I agree with are as follows. The first is that the decision in Kashinath is not good in law because it ignored a binding constitutional bench ruling in Kartar Singh versus State of Punjab, which was a 1994 case, which said that right to anticipatory bail is only a statutory right which was added by the Criminal Procedure Code of 1973 and not a fundamental right guaranteed by Article 21 of the Constitution. Now, it's not my case that the right to anticipatory bail is not part of fundamental rights. But the question is that this was exactly an issue that perhaps should have been referred to a larger constitutional bench because there was existing precedent on this issue. The second problem is, of course, as I mentioned, it distinguished the Balotia case inappropriately because it should have referred the matter to a higher bench. So that's an issue simply about the nature of court rulings and processes. But the second question is a larger one, which is about the Supreme Court's double standards on personal liberties of the accused. Because it is not the case that the right to anticipatory bail or these provisions that have diluted procedural safeguards apply only against the atrocities provisions of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. There are there are laws that dilute the personal liberties of the accused in various laws like TADA, the Terrorist and Disruptive Activities Act, POTA, the Prevention of Terrorism Act, UAPA, the Unlawful Activities Prevention Act. There are many such laws which dilute rights of the accused. But the court has not really upheld the rights of the accused in those laws. In fact, there are cases on TADA and POTA where the court has not said that these weakening of procedural safeguards is a problem. Only it has done so in cruelty against women, that is section 498A IPC, another very vulnerable group, in fact perhaps the most vulnerable of all, because we find that even when we talk about tribal communities also, tribal women are the bottom of the hierarchy. So the only two cases where the court seems to be protecting the rights of the accused are actually section 498A and Prevention of Atrocities Act, which is about the most vulnerable groups in the population. And finally, the decision is very problematic because the government did not furnish any adequate data on atrocities to the court. And the court seems to have wrongly derived the conclusion of that low rate of convictions in atrocity cases is an evidence of misuse of the act. Whereas it could very well be, as many have argued, that it is actually because it's an uphill struggle for a vulnerable group or a community to get justice. And that's why conviction rates are low. So it was against this backdrop that we started this research to understand the data on atrocities. But before I hand over to Ankit to speak about the data, just for those who may not know, quickly to mention that after the Supreme Court judgment, there was a huge furor. Parliament has now amended the act to do away with the Supreme Court provisions. But recently there was a Bandh call that was called by groups, that upper caste groups who were protesting against this decision. So this is an issue which is definitely dividing society at this point. So having some data, real data to understand the issue is, I think, the need of the hour. And it is with that goal that we have done this analysis.
Thank you. So, in this background, as discussed earlier, what we have tried to do is to put together a database on atrocities against STs for a period of last five years, from 2011 onwards. As it has been that this kind of data which is coming from National Crimes Record Bureau has been reported in different outlets. But one thing that we found, that what has been reported is actually sometimes is a very short-term phenomena. So there could be nothing conclusively said about it until unless we test it for a little bit longer time, so that we are sure that whatever the trends that we are obtaining from that is actually conclusive in terms of their spatial distribution or in terms of the other reflections that we can draw upon them. So just to begin with that, I would just like to highlight one thing which is generally given as a criticism of the NCRB data is the principal offense rule, which is generally that the offense which is the offense which has the maximum punishment is only recorded under the NCRB data. But a caveat is that this principal offense rule is not applicable for the atrocities data, the way it is recorded with the NCRB. So it means that the NCRB data, when it is recording the atrocities against STs, is essentially recording all the crimes which has been listed in the FIRs. And for this purpose of the analysis, since we have begun our analysis from 2011 onwards, so we have treated the states of Andhra Pradesh and Telangana as single unit, that is the state of Andhra Pradesh as it used to exist earlier. So the data that is reported under the NCRB is reported under various different categories and subcategories. But to present the analysis in a way that we can infer something out of it, we have tried to merge some categories which are very closely related. For example, like some of the things like the crimes which are generally can be perceived to be against women have been classified. These are the four categories, such as like attempt to commit rape, and other molestation and other things which are specifically related to the women. So we have called these four categories as atrocities or the crimes against the women. And similarly, we have gone further in terms of like we have clubbed kidnapping and abduction as a single unit, arson and riots again as a single unit, and robbery and dacoity as a single unit. So overall, after this clubbing of the different categories under which the data was provided, we have the 8 broad categories under which I will be representing some of the findings that we have found from this study, which spans for 5 years. So why 5 years, as I was explaining, is to be conclusive about the trend is not a 1 year eccentricity, but actually is a conclusive evidence of what we are able to find. So the first thing that we find is like, just to set the context, is that what are the number of atrocities that actually we are that are getting registered every year. So if we look at the orange line, which is the lower bar, that is reflecting the number of atrocities against scheduled tribes, and there is a blue bar just to give a context in a comparative way with the scheduled caste. We see that the number of atrocities are in the range of roughly 5,700 to 6,000. That is the number of atrocities which is being registered every year. And there is a steady growth of around 2% on average for this period of 6 years. But in case of scheduled caste, I will not go into much detail, but those are very much higher as compared to the scheduled tribes, and even the growth rate is even higher in case of the atrocities for the scheduled caste. But to just give a context of like what do we make out of this number is that in terms of the total crimes that are being committed in our country on an yearly basis, it's a very small proportion, somewhere in the range of 0.25% to 0.22%. So that's like a quarter percent of the total crimes. So in terms of the relative proportion of the total crimes, yes, there are not so many, but in terms of the individual importance, I think it's an interesting topic to study further. So by analyzing all the data for 5 years, on average what we find that based on the different categories of which the crimes are coming, so one of the biggest categories is the other IPC crimes, which is a combination of various sections and various smaller groups. So as expected, it's a very high number, around 47% of the total atrocities on average for 5 years are coming under the category other IPC crimes. But the interesting thing is the next category, which is crimes against women. As I said, that it is a combination of just 4 categories, and it's a very specific in terms of what we can get out of this is around 20% of the total atrocities on average for 5 years are against women, are against tribal women. And then the next categories follow, as we can see, like there is a Prevention of Atrocities Act without IPC, murder and grievous hurt, and so on. After understanding what are the atrocities which is based on the different crime categories, next we wanted to understand like what are the states from which these atrocities are being registered. And we find that on average for 5 years, the maximum number of atrocities which has been registered are from Madhya Pradesh and Rajasthan, roughly around 22% each, and followed by Andhra Pradesh, Odisha, Maharashtra, and so on. But one interesting thing is that these top 10 states, which are highlighted in this graph, contribute to around 90% of the all atrocities. And of these 10 states, first 5 states are scheduled area states. And of the 10 states, 8 states are scheduled area states. So 8 states out of this, which contribute to 90% of the total atrocities, are coming from scheduled area states, where again like tribal population is in majority at different pockets, which we have presented earlier in our presentation.
And the interesting thing is they're all 5th schedule area states.
Yeah. Now we wanted to compare, as we know, like the different, the number of crimes or the number of atrocities which are coming from different states are different, but that can entirely happen because the number of ST population is actually varying across different states. So now what we have done, we have put it in comparison form where Madhya Pradesh, all the lines in blue as were presented earlier, like Madhya Pradesh, Rajasthan are the topmost categories, but the orange bars which are next to them are actually reflecting what proportion of the total ST population that these states have as compared to the total ST population of a country. So, Madhya Pradesh has around 14% of the total ST population of a country, but it is registering around 22% of the total atrocities against STs. And same goes for the other states. Just to read, Rajasthan has around 8%. Andhra Pradesh has around 5% of that contribution. So from this, what we are trying to say is like we can see that there is something. If we want to draw something meaningful out of it, we need to see what are the number of atrocities in context of what is the relative contribution in terms of their ST population as well. And very simply, we can draw that Madhya Pradesh has more than proportional atrocities, because if there is only 14% of the total STs which are from Madhya Pradesh, but 22% of the atrocities are from Madhya Pradesh, that means they are more than proportionately contributing or have more incidences of atrocities. So based on this simple logic of being proportionate, we have drawn a very simple metric that is trying to capture like how much extra or how much less in proportion to the relative ST population is each state contributing to the atrocities. And we call it, it's a little technical term, it's called coefficient of disproportionate atrocities. But logic is very simple. If you're contributing more than your relative proportion, you are doing disproportionately higher. And if you are doing less than your proportion, you are doing a better job. So based on that, okay, fine. We understand that the different states have different kind of trajectories in terms of the atrocities, and they have different level of ST population. But can we compare one state from the another? Can we compare how is Madhya Pradesh doing as compared to Rajasthan? Maybe it was simpler because the atrocities were similar and the ST population was up and down, and we can just clearly feel that Madhya Pradesh, Rajasthan is doing a worse job than Madhya Pradesh because it only has 8% of the population, but ST atrocities are 22%. But this kind of intuitive comparison is not true for all the cases. And to do that kind of analysis, we have drawn this metric where we are able to empirically measure the performances of different states, that how they are doing in relation to each other. So by doing that calculation from the simple metric, what we found that all the states which are shown in orange on the left are actually the states which are actually doing a bad job in terms of their contribution to the atrocities. These are the states which have more than proportionate ST atrocities as compared to their contribution to the ST population in India. And vice versa, the states which are in blue are doing relatively good job. This is not to say that this is not to justify atrocities in any way. In absolute term, every crime or every atrocity is something wrong. But just to compare the relative performance of different states with each other and to have some kind of dialogue or some kind of policy framework, it is important to assess the relative performance of different units or different states over there. So based on this, we have drawn this simpler map. The map is a state-wise distribution of a country where all the green color shades are the states which are doing relatively good. That does not mean that they don't have atrocities. That just means that in terms of their relative contribution to STs, the number of ST atrocities are less. And vice versa, the states which are mentioned in red are doing a worse job. Again, we have a two-color range in both for green and red. The maroonish color are actually which are doing extremely bad as compared to the red color one. I hope it is clear from the graph. Yeah. So for example, Rajasthan over there is maroon in color, whereas Madhya Pradesh is red in color. And we have a matrix that how we have classified that in terms of at what level we make a cutoff, that is when it becomes a very bad state to when it is a bad state, when it is a good state, and when it is a relatively even better state. So we have that empirical measure with us. So just to see the Rajasthan and Andhra Pradesh and Telangana, which is a combined unit, are doing pretty badly as compared to Karnataka, Odisha, and Madhya Pradesh. And the other states, including the entire Northeast, is doing in this ground a good job. Again, this is entirely because the ST population over there in some of the regions are in actual majority. So this issue has to be seen in that lens that they are actually majority population. And if they are doing good job, it is at the cost of someone else. So again, the minorities over here are not STs, but other people, and so we have to see this finding in that lens also. The definition of the majority is changing in these two contexts. So yeah, this is like again based on what we said, that the court found that the acquittal rates were very high, which again is pretty true for a study of 5-year period, where on average we find that so the red color dashed bar on the top is a national average of the conviction of all the crimes in our country, which is roughly around 42%. That is 42% of the trials which are being completed have a conviction rate of around 42%. But if we compare this with what is happening in terms of the conviction rate for the atrocities, we find that it is actually somewhere half. The conviction rates are only 22%, which means that the acquittal rates are disproportionately high. So this argument actually holds true. But what is the conclusion that we can draw from this argument can be very different. Like why it is actually happening. Is it true that is a wrongful acquisition, or there is something else that is going on that we can that is what we can deliberate on?
So just to add to what Ankit was saying, there are two different trends that are coming out. There are certain states where registration of atrocities compared to the percentage of tribal population is much higher. Now that can have two interpretations. We don't know which one is true. One is that there is more crimes against scheduled castes and scheduled tribes that are happening in those states. Or it could be that the scheduled tribes in those states are actually registering FIRs as opposed to other states. So it can mean both empowerment and disempowerment. And we don't know at this stage what that actually means. But what we do know, at least based on this, is how states are performing. And we would really hope to hear from our panelists who are coming from the different states. How do they see this data from their own experiences? The second finding is about convictions. Basically, the Supreme Court's derived from the low conviction rate, which is corroborated by our analysis of the NCRB data, was that misuse is happening. But actually, it could be the other way around, that in fact, conviction rates in these crimes are much lower as compared to the general population, because the general population has more ability and resources to use the criminal justice system to actually hold people to account, as opposed to the tribals and as opposed to the because I mean, as we've already shown, 20% of all crimes were against tribal women. And a lot of these have serious crimes of rape and so on. And in order to supplement this data, we actually started this process of analyzing all the Supreme Court and High Court decisions on atrocities. And so far we have looked at the Supreme Court decisions on atrocities. Again, between groups also we see a difference in the sense that it's scheduled castes, atrocities against scheduled castes that have dominated the literature about this issue. Again, scheduled tribes are even below scheduled castes in that sense in terms of atrocities. Even in terms of the cases that have been decided by the Supreme Court, there were 25 identifiable cases which were about scheduled caste atrocities, only 8 that were about scheduled tribes. But even there we are seeing the same trend. Out of the 8 cases decided on substantive legal questions involving scheduled tribes, 6 were crimes against women. And serious crimes of rape or molestation and so on. So, and now even in the High Court cases, this trend, we haven't completed the work, but this trend is coming out that crimes against tribal women is a very large category, which is not necessarily true for crimes against scheduled caste women. But somewhere there is something which is going on about the crimes against tribal women is a very significant category. And we would again want to hear and understand why that is the case. But another interesting thing that Ankit has brought out, which is that, you recall, can we go back to that graph, the 10 states, because that is also, anecdotally we know the Lok Sabha debates on the Act talked about land disputes, but it is very telling that of the 10 states, they are all states, except for Kerala and Karnataka, they are all 5th schedule area states. And I think that there would be an interesting thing to see how, what these atrocities, how they correspond to land-related displacement and so on with respect to, because even though a crime, Atrocities Act defines dispossession of tribals as a crime, but usually what happens is that there may be a crime of murder over a land dispute, which will only be recognized as a crime of murder. It will not be recognized as a, because that is the principal offense and the other things. So it is not possible always to find out what are these crimes about, just from this data. And from the judgments of the Supreme Court and High Court, yes, we can identify some things, but then there are much fewer, obviously, because only those many cases go to the High Court and to the Supreme Court. But those are some of the ways in which we can proceed with this research.
So following the session on the atrocities, next what we wanted to understand is like what is happening in terms of the criminal conviction of the STs themselves. At the first they were the victims. Now what is happening in terms of when they are doing something and what is the kind of conviction or the acquittal rate for them. So again we got this data from NCRB report, and this data is on the prisoner statistics. And on the similar line, this is again a trend series analysis that we have done for 5 years. And all the data that we'll be presenting is like an average finding for the 5 years to again remove the short term, any specific year variation that we can find. So just to read what is the meaning of convict in this thing, I will just read it out, which is coming from the methodology. Like what do we mean by convict under this data repository? Any prisoner under sentence of a court exercising criminal jurisdiction or court martial, and includes a person detained in prison under the provisions of Chapter 7 of the Code of Criminal Procedure of 1973, that is the Central Act 2 of 1974, and the Prisoners Act of 1900, Central Act number 3 of 1900. So with this definition, this data has been created by NCRB and is available in the public domain. And based on this, we have done the analysis of 5 years. And again, like in the previous section, we have assumed the state of Andhra Pradesh and Telangana to be a single unit, that is the state of Andhra Pradesh. So just to set the context again, so in terms of the number of prisoners for SCs and STs, there are around 17,000 prisoners in the year 2011, and roughly they don't have a simple trajectory in terms of they have been a little bit up and downs, but on average, if we see in last 5 years, they have gone a little bit down. But the number is around 17,000 prisoners of STs, and as compared to the SC prisoners are more than that, which is around 26,000 SC prisoners on a yearly basis. But just to compare, okay, fine, we have so many ST prisoners, but are they proportional to the total number of population? As we know, the STs are 8.6% of the total population of our country, and the number of prisoners are 17,000, but as compared to the total prisoners of our country, they are disproportionately high. So the number of prisoners on average is around 13 to 14%, which again has a year-wise variation, but so disproportionately on all the years that we have analyzed the data, the number of ST prisoners are disproportionately high as compared to their relative contribution to the total population of the country. I have not found this thing, but it is also similar for the SCs, this kind of trend. So next, going with the similar kind of analysis, that we wanted to see what are the states which have like the highest number of ST convicts in comparison to what is the contribution of the relative contribution of the ST population in their state. We find that Jharkhand has the highest number of the convicts, which are scheduled tribe convicts. I think I can read from here, but it is around 31% of the total convicts are scheduled tribe convicts, followed by Chhattisgarh, Odisha, Madhya Pradesh, Gujarat. Again, the pattern is that they are again scheduled area states. But when we are trying to compare them in relation to what is the relative proportion of the ST population in these states, which is highlighted in the orange bar next to them, we find that Jharkhand also has a good high proportion of the ST population, because as we know, and again Chhattisgarh has it. But if we see the first 5 categories, that is up to Madhya Pradesh and Odisha, and even for Rajasthan further, the blue bars are higher than the orange bars, which basically shows that disproportionately again the conviction of the STs in these states is higher as compared to what is the relative contribution of the ST population in the states. And interestingly, again, up till Rajasthan, which is like first top 6 states, they are again 6 scheduled area states. The only exception is the Uttarakhand and then Karnataka. So again, in terms of the conviction, again we see that there is a disproportionately high conviction of the STs as compared to their relative proportion. But again, in terms of the top ranking states, these are again top 6 scheduled area states which are coming over there. Sorry, 5th scheduled area states, just to be very precise. This is something which I have already highlighted, but just to put in context, this is just a map which is comparing the fifth scheduled area states. So first blue and the orange bars are the similar, that is the conviction rate of the STs, and orange bar is the relative proportion of the ST population. Here we were trying to see how much the geographical area which we found from our previous presentation, the scheduled areas which are there in these states, do they have any kind of correlation? But we were not able to find any particular correlation or any direction in terms of the area. But again we find that the finding is that the scheduled areas are the top ranking states in terms of the disproportionate ST conviction as well. The only state which is again and again as an exception to the most of the things which the other scheduled area states are following is the state of Himachal Pradesh. It has a very different kind of dynamics, and we would like to know more why it is happening. But it is generally seen not only for this data but for various other indicators also, the Himachal Pradesh don't seem to follow the trend which the other scheduled area states are following. And maybe it is geographically very, very different and is isolated from the other tribal dominated states. But there is something which is very peculiar about Himachal Pradesh that we need to understand in the state-wise deliberation of that. Again, following the same logic that we wanted to understand disproportionately how much STs are being convicted in different states, and if we can empirically measure them. So again, on the same lines with the same logic, the orange bars on the left show the states which are doing a poor job, and the blue lines on the right are showing the states which are doing a good job. And in terms of the map, if we see the previous map, if you remember that there was a lot of green color into it, because a lot of states were actually disproportionately the atrocities, they were doing a relatively better of job. But in terms of the conviction of the STs, we see the most of the map is actually red. So this shows that in terms of the conviction of the STs at different states, most of the states are not doing that good job. Again, the color codes are similar, that is maroon color are the states which are doing even worse than the red color ones, and the green ones are those which are doing relatively better of job. But one exception that comes is the state of Assam in this case, which again has shifted from green category in the earlier map that we showed for the atrocities to a red color in this thing. So the conviction rate in Assam is again for STs is relatively high, and Assam is not a tribal majority state for STs. So yeah, these were some of the findings that we were able to build based on the NCRB data. The findings are limited to the state level analysis because that is what the data that we were able to publicly get from that. And we are also in the process, and we are actually very inclined to do a district level analysis of this sort and actually do a stronger correlations with the other scheduled area districts which we presented earlier. That would be our next line of inquiry. We are very much inclined to do, but for now we are limited to the state level inquiry. Yeah, so we are in the process of accessing that data, the district level data. It seems that data is not available in the public domain for now, but we are talking to the different government departments in case we can get an access of this kind of data. Even the data which is further disintegrated at further level, we will be able to find further interesting analysis based on the crime categories across different districts, what is happening. Compare what is happening within different districts as compared to what is happening in one district to another districts, what is happening in one scheduled area district to another one. We can do all that kind of a more granular approach to our analysis can come, but we are still limited by the data that we have as of now.
That's where if the Commission can probably help us in getting access to that data. And I believe also there are some representatives from the National Crimes Records Bureau here. Is there anybody here from NCRB? So that would be our appeal to them, is to release the district level data, which they have done for previous years, which will help us build a more detailed and granular, nuanced picture of these things. But you know, even from this data, what is coming out really clearly is the fact that while atrocities cases that are registered by scheduled tribes are quite low in all states, but criminal convictions of STs is quite high in all states, which basically means that, you know, the criminal justice system is working to the disadvantage of the scheduled tribes. And as I mentioned earlier, that, of course, there are different, categories of crimes, but the fact that 20% of all crimes are crimes against tribal women is particularly striking and sad. So to conclude, the Supreme Court in a landmark judgment last week, Navtej Singh Johar versus Union of India, which basically decriminalized homosexuality in India by reading down Section 377, has highlighted through various judgments that the fundamental rights chapter is the North Star of the constitutional universe, and that the individual is key to the protection of the Constitution's guarantees. So clearly the constitutional commitment to personal liberties of all citizens is paramount. The Constitution itself says that. The Supreme Court has deeply affirmed that in the Navtej Singh Johar case, but also in the privacy judgment, the Puttaswamy case. But all are not born equal, and therefore exceptions have been created within the constitutional framework for protection of rights of vulnerable groups like scheduled castes and scheduled tribes. Our data clearly shows that criminal convictions of STs relative to their population remain disproportionately high in a majority of states. The worst offenders are Uttar Pradesh, Uttarakhand, Tamil Nadu and Bihar in terms of criminal convictions of STs. There is a steady increase in registration of atrocities cases registration of atrocities against scheduled castes and scheduled tribes. The maximum number of, with respect to scheduled tribes, the maximum number of registered atrocities cases are in the states of Madhya Pradesh, Rajasthan, Andhra Pradesh and Orissa. And as we mentioned before, these are all 5th schedule area states. It is not clear whether the rise in atrocities cases is because the actual number of offences is going up, which would indicate greater vulnerability of scheduled castes and scheduled tribes, or that there is a greater registration of offences, which may be indicative of greater empowerment within these communities. Tribal women, however, are most vulnerable. 20% of all ST atrocities are crimes against women. This is corroborated not just by the NCRB data, it is also corroborated by our analysis of the Supreme Court judgments and the ongoing research on High Court judgments. Clearly, this is a very disturbing feature of atrocities against scheduled tribes, and it just shows that even within vulnerable groups, not all are born equal, and that the women are much worse off in terms of these things than as compared to the men. The conviction rates for atrocities against scheduled tribes are just about half the national average for conviction rates for all crimes registered with the NCRB, which means that the criminal justice system is actually not resulting in enough convictions in crimes against scheduled tribes. So therefore, for the Supreme Court in at least from this data, we can say that for the Supreme Court in Kashinath to infer low rates of convictions for SC/ST cases to indicate misuse of law was not appropriate because it is in fact perhaps an indication of the greater social imbalance of power between the SC/ST communities on the one hand and the rest of the population on the other. And if there is this imbalance, which we know anecdotally and the data is also showing, then it has to be redressed through stronger legal protections, not weaker legal protections, but also more targeted interventions specific to each state. And that is where we need to figure out. For instance, there was research that just came out in a newspaper about the use of the Unlawful Activities Prevention Act in UP against Muslim minorities and so on. So the fact is that we need to see what is going on in each of these states. Like, UP is also one of the offender states in terms of like convictions of STs relative to ST population. So we need to figure out what's going on there. But obviously law is not enough. That was a point that was made even in the previous session. We need administrative and police reform, because we can pass all these laws, but if the police are not going to register those complaints, I mean, we have a series of bad judgments from the Supreme Court on rape cases and cases of crimes against women anyways. I mean, so it's a bad performance on the police and so on, but also in the way the court treats the prosecutrix or the victim in those cases, so which shows the social biases that are inherently built within a sort of patriarchal society. So law is not enough. We need administrative and police reform, but we also need changes in social attitudes through education and through sensitization. So I think that's where we will leave it at. The data is open for interpretation, and we really welcome